Hello, my name is Muhammad Safyan and my student ID is 240877784. Today I am presenting on behalf of Beamer's Law. I will be explaining the implied terms under section 12, 13 and 14 of the Sale of Goods Act 1979. Before we look at the specific section, let me quickly explain what implied terms are. When two people make a contract to buy and sell goods, the law automatically adds certain terms into the contract. This is called implied terms. The main law we are looking today is the Sale of Goods Act 1979. This act was updated by the Sale and Supply of Goods Act 1994. It is also worth noting that for consumer contracts, meaning contracts between a business and a normal customer, the Consumer Rights Act 2015 now applies, but for business to business contracts, the Sale of Goods Act 1979 still applies. Today we will be focusing on 1979 Act. Let us start with section 12, which is about title. Title simply means the legal right to own and sell something. Section 12 subsection 1 says there is an implied condition that the seller has right to sell the goods. Section 12 subsection 2 then gives the buyer two implied warranties. First, the goods are free from any charge or burdens that the buyer was not told about. Section 12 subsection 1 is a condition. If a condition is broken, the buyer can reject the good and also claim damages. But section 12 subsection 2 only gives warranties. If a warranty is broken, the buyer can only claim money compensation. They cannot reject the all goods. Let me now look at the key case for section 12. The first case is Roland v. Deval from 1923. In this case, a car dealer bought a car from defendant. After using the car for 2 months, the police came and took it back because the car had been stolen. The defendant had no legal right to sell it. The court held that this was a breach of section 12 subsection 1. The buyer was entitled to recover the full purchase price even though he only used it for 2 months. The reason was that there had been a total failure of consideration. The second case is Niblet Confectioner Materials from 1921. Here, a seller supplied tins of condensed milk, so the Nestle's got a court order preventing the resale of those tins. The court held tin was a breach of Section 12, even though the the seller physically owned the tins. The third case is Microbeads v. Windhurst Road Markings from 1975. In this case, goods were sold lawfully, but after the sale, a third party obtained patent over the goods and then disturbed the buyer's use of them. So, the warranty of quiet possession, this shows that the warranty of quiet possession can be broken even after the sale has already taken place. Now let us move on to the section 13, which is about sale by description. Section 13 subsection 1 says that where goods are sold by description, there is an implied condition that the goods must match the description. Second, a sale can still be by description even if the buyer has seen the goods. The key question is whether the buyer was relying on the description. The third section 13 is only about description, not quality. Quality is covered separately under section 14. And finally, under section 15, a non-consumer buyer cannot reject goods if the breach of section 13 is so minor that it would be reasonable to reject them. Let me go through the key cases for section 13. The first case is Bill v. Taylor from 1967. The defendant advertised a car as a 1961 Triumph Herald 1200. The buyer came to inspect the car and bought it. Later on, it turned out that the two cars were well together. The half part was of 1961 and the half part was not of. So the uh, so even though the buyer had seen the car, he had still relied on the description in the uh, advertisement. The second case is Remoor and Co. v. Landur from 1921. In this case, a contract was made for tin fruit to be packed in case of 30 tins. The correct total number of tins was delivered, but they were packed in case of 24 instead of 30. The court held this was a still breach of section 13. The third case is Harlington and Leinster v. Christopher Hull Fine Art 1991. A painting was described as the work of a particular artist, but it was actually a forgery. Now we come to section 14, which deals with quality and fitness for purpose. Section 14, subsection 1 sets out the general rule there is no automatic implied terms and quality for fitness for purpose unless the specific rules in section 14. The most important point about section 14 is only applies where the seller is selling in the course of a business. So section 14 then gives us two key implied terms, section 14 subsection 2 about satisfactory quality and section 14 subsection 3 about fitness for particular purpose. Section 14 subsection 2 says that where a seller sells in the course of a business, there is an implied term that the goods must be of satisfactory quality. So section 14 subsection 2b then lists what quality includes. Goods must be fit for all the purpose they are commonly used for. Section 14 subsection 2c, the implied term does not apply to defects that were specifically pointed out to the buyer before the contract. The first case for section 14 subsection 2 is Roger v. Parrish from 1987. The buyer purchased a brand new Range Rover for around £16,000. Within weeks, the car developed many problems. So the court said that the buyer who pays a high price for a prestige vehicle has a right to expect comfort, reliability, appearance, and pride of ownership, not just a car that can be driven from one place to another. The second case is Grant v. Australian Knitting Mills from 1936. Dr. Grant bought woolen underpants. They contain excessive sulfide chemicals left over the manufacturing purpose. So the court held the goods were not fit for the purpose of being worn next to the skin. This case also shows the hidden defects that are not visible on inspection. Section 14, subsection 3 covers fitness for particular purpose. It says that where the seller sells in the course of a business and the buyer makes known to the seller any particular purpose for which they are buying the goods, there is an implied condition that the goods must be reasonably fit for the purpose. Section 14, subsection 3 does not apply if the buyer did not rely on the seller's judgment or if such reliance was unreasonable. The first case here is again Grant v. Australian Knitting Mills from 1936. Dr. Grant simply asked for woolen underwear. He did not say anything specific about purpose, but the court said that the purpose wearing them next to the skin was completely obvious from nature of the goods. Breach of section 14 subsection 3 was established. The second case is Griffiths v. Peter Conway from 1939. A woman with unusually sensitive skin bought a Harris tweed coat. The coat gave her dermatitis. However, a person with normal skin would not have been affected to the all. The court held there was no breach of section 14 subsection 3. Now let me briefly explain what happens when these implied terms are broken and whether sellers can exclude them. Starting with the exclusion under the Unfair Contract Terms Act 1977, Section 12 of the Sale of Goods Act. If a warranty is breached, there is Section 12 subsection 2. The buyer can only claim damages. There is no right to reject. To summarize everything I have covered today, Section 12 protects buyers by ensuring the seller has the legal right to sell. The key case is Roland v. Devil. The seller must also ensure the buyer enjoys quiet possession of the goods. Section Section 13 protects buyers by ensuring that goods match their description exactly. The key cases are Beale v. Taylor and Remore v. Landor. So together these three sections form the most important protection for buyers under English sale of goods law. Thank you for listening. My name is Safyan, representing on behalf of Beamer's Law.